Today, I want to discuss a common, though infrequently discussed issue that arises when a child wants to immigrate a step parent. The situation often arises like this: a child born in the United States to an immigrant parent who has raised them alone, perhaps because of a divorce, perhaps because of a death to the other spouse, or for some other reason, remarries or re-engages in a relationship with a new person who's also an immigrant. Can that child immigrate not only the biological parent, but also the immigrant step parent? And the answer is yes, in certain circumstances. The basic rule for any child to immigrate a parent is that the child must be 21 years of age and the child must be a United States citizen. So if the child is born in the United States and they're now 21, they can proceed to immigrate their biological parent. Does that rule extend to a step parent? Well, it does, with an extra dimension, an extra requirement. And that's what was the age of the stepchild at the time of the step parent, biological parent marriage. If it occurred before the stepchild was 21, then the stepchild can proceed to immigrate not only their biological parent, but also their immigrant step parent. What often happens in my practice is that a family of three comes into my office. The child has just turned 21 or is about to turn 21 and wants to immigrate his or her two parents. One of the parents is the biological parent, the other's the immigrant step parent. So the question is, can they immigrate that step parent? And the answer is yes, if the marriage was consummated before the child turned 18. If the step parent and the biological parent married when the stepchild was 19, well, then the step parent is out of luck. The stepchild cannot immigrate him or her. Even if that step parent has raised the child for 10 years beforehand. Perhaps the step parent and the biological parent entered into a close relationship when the child was 7 or 8 or 9 years old. It doesn't matter if they were not married before that child was 18. However, there is a caveat, and it's often missed in these cases. I have seen cases where individuals come to me after their petition has been denied when it shouldn't have been denied. And that's because the family has recently moved to where my main office is located in California. But previously, they lived in a different state. And that different state recognized what is known as a common law marriage. A common law marriage is when the couple, the biological parent and the step parent, hold themselves out to the world as if they were a bona fide marriage, as if they had taken the vow and they had been sworn in and they had registered with the county in which they live. They commingle funds, they commingle assets, they pay debts together, they pay taxes together, and for all intents and purposes, they have held themselves out to the world as if they're husband and wife. In certain states, there are requirements, and if they meet those requirements, and the requirements differ from state to state, but if they meet those requirements, then they can show that they have a legitimate common law marriage. Some of the states where that's the rule are Colorado, Kansas, New Hampshire, Texas, Utah, and there's others. Now, in that case, if the individual who wants to immigrate the step parent, the immigrant step parent, if their family had lived in one of those states before the child was 18, and the biological parent and the immigrant parent had held themselves together as if they were a bona fide marriage couple, and that would have been recognized in that state, such as Texas or Colorado, well, then that marriage is a bona fide marriage for purposes of filing the petition. And so if they held themselves out before the child was 18 and they could meet those requirements before the child was 18, well, then that's a legitimate marriage. Even if the family moves to another state, like California, that doesn't recognize common law marriages, it will still be recognized in California because it was recognized in Kansas or Texas or Colorado. So you have to be careful, especially if you have moved from state to state. I've noted, as I said, in cases that have come to me after the fact, that that's an issue not spotted by the family or by the representative or attorney who's helping them. Very careful. Think about that. If you've lived in multiple states and that's your situation, you need to look carefully at that. And that rule about common law marriage may apply in other immigration contexts as well. So that's an issue that you should be alert to going forward. There's one other requirement, and that's that the stepchild and the immigrant step-parent must have an ongoing relationship. Because the stepchild is now 21 when they file, some of the rules that would have been necessary when the child was younger, 18, 17, 16, such as child support and providing for the child's living expenses, the clothes, the school tuition, and other things, aren't going to be as necessary to show. The government may require that you show that before the child turned 21 and they were living in the same household. But a lot of children 21 are now on their own, going to college, or they have their own apartment, they're working full time. And so the ongoing relationship will be of a different nature. What will destroy that is if the relationship between the immigrant step-parent and the stepchild, the United States citizen stepchild, are not that close. If it's not a close relationship, or if something hostile has happened, perhaps now the step-parent and the biological parent aren't getting along and they've separated or they're divorced, and so the immigrant step-parent has cut off all communications with that stepchild. Well, that may affect whether or not the stepchild would immigrate to step-parent. But in reality, why would that stepchild then want to immigrate to step-parent if they're not close? So in most cases, that requirement of the ongoing relationship is going to be met. Now, and this rule counts even if, not only in cases of divorce, but even if the biological parent has passed away. As long as those requirements can be met, then the stepchild can still proceed to immigrate their step-parent. So those are the issues that you need to look at if you're in such a situation. The age of the stepchild, 21. The status of the stepchild, U.S. citizen. The date of the marriage between the step-parent and the biological parent. Was it before the age of 18? Or did they perhaps live in a common law state? And whether or not there's an ongoing relationship. You meet those 4 requirements, then you can proceed. One caveat is that make sure that you look at the immigrant step-parent's history, immigration history. If they entered without permission, or if they entered with a visa but overstayed, that may ultimately affect them at the green card stage. Not in terms of filing a petition, but down the line afterwards when they apply for permanent residency. With that, I wish you all the best of luck in the world, and keep your chin up and just push forward, and always look at other options. If you can't meet this option, there may be others. Take care and good luck. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below or feel free to contact me at carlos@VitaraImmigrationLaw.com. My name is Carlos Vitara. I appreciate your time and hopefully we'll be talking again very, very soon.